Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
We're back with you. Yes, good afternoon and lovely people. Thank you very much for your time. It is the community and the law, and we coming your way with a very interesting discussion. The question is how to successfully switch to skilled worker from a student dependent if even your partner or your spouse did not complete their studies. We're doing that for the next 2 hours, and I'm doing that courtesy BWF Solicitors, our trusted partners when it comes to the law. 214-218 Tottenham High Road, that's where they are, on the 4th floor of the Anna House. My name is Oreku Sifrimpon, and let's get into this together.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our
Our senior partner, with over 30 years of unbroken service to the community,
is a member of the Family Law Panel
and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Yes, I have paid tribute to BWF Solicitors, and now we're going straight into action. Now, earlier in the week on Monday, you had the nugget coming away, and we had this to grapple with. Those who married an EU national after December 31, 2020 cannot get pre-settled status under the EU settlement scheme unless they previously had or applied for an EE resident card or family permit as their durable partner. Even those who were waiting for their marriage to be approved because of COVID-19 did not qualify. The best route for these spouses is to apply under the immigration rules, providing evidence of language, maintenance, and accommodation. A far cry from pre-December 2022 EU requirements. This is a Selig and Secretary of State case for the Home Department. We're talking about 2022 England and Wales Court of Appeal case. Yes, I was trying to go through my mind to see what the EWCA meant. And with that, I would go to do the traditional thing where I'm going to introduce my resource person and my guest. And it's no other person than our brother, Charles Asma, lawyer Charles Asma from BWF Solicitors. Uncle Charles, good afternoon.
Good afternoon, Brakoku. How
are you doing, my boss?
It's a pleasure. Doing well, thanks.
Thank you very much. I was trying to be a lawyer myself, but I just realized in the middle of it that I am not qualified to do so. So I'll come your way and kindly ask you to look at our nugget again. I'll have a quick read of it, and then you will, as you normally do, take us through it, why that situation. There's a case that came, there's a Court of Appeal case in 2023, this very year, and is Selig and Secretary of State for the Home Department. Now, this case says those who married an EU national after December 31 cannot get pre-settled status under EU settlement scheme unless they previously had or applied for an EU resident card or family permit as their durable partner. Even those who were waiting for their marriage to be approved because of COVID-19 do not qualify. The best route for these spouses is to apply under the immigration rules, providing evidence of language, maintenance, and accommodation. That's a very far cry from the pre-December 2020 EU requirements. What is this talking about, lawyer?
Thank you very much. Good afternoon to you, cherished viewer and listener. So we know that the courts have prevailed upon the Secretary of State to do things favorable to EU nationals in the UK and their family members, which includes automatic grant of 2 years for those whose leaves are about to expire and they are on the pre-settled, which we know it doesn't mean that you don't have to extend if you have to extend to get your settled status. So you can see that was a positive outcome from the court.
Right.
Now we're also looking at another outcome from the same court, which says that the groceries from the courts is only necessary for those who deserve. And therefore, we have two categories of people within the EU spectrum. We have people who have married EU nationals and people who have not married but have been living with EU. And therefore, because of that, living together or that relationship, the law says that that relationship is akin to marriage or similar to marriage.
Okay.
And therefore, if you have lived with a person for 2 years, the law sees you as partners or couples. So if you have lived together for 2 years and you have not married, you can apply to get your pre-settled up to the cutoff point. Now, what it means is that you should show that you have lived together for 2 years at the time everybody was asked to make an application. So we are looking at 31st of December 2020 cutoff point. We're also looking at those who choose the marriage route. And therefore, if you have not lived together for 2 years and you are not in a durable relationship, then you should have married the person by the 31st of December 2020. If you married the person after that date, the person was not your family member. And that's the phrase to remember, not a family member by 31st of December 2020. So if the person is not a family member by 2020, then such applications cannot fall under Appendix EU withdrawal agreement provisions. And if you're also a durable partner, what it means is that you qualified by the 31st of December. So I'm sure that person would have already applied to be given the residence card. And therefore, even after 31st of December 2020, if they married, because they have already been granted a card based on durable relationship or partnership, they are right to continue as though they were family members of EU national. So what the court is saying is that if you cannot prove that you are a durable partner of an EU national, and you cannot also show that based on your durable partnership, you've been granted residence card, then if you marry later by the 31st of December 2020, you cannot make any excuse to show that you couldn't marry early for whatever reason. The key thing is either you married before 31st December 2020 or you were in a durable relationship and got your card based on that durable relationship. So these are the two
So
gateways.
let me try and understand this. If I had my traditional marriage in Ghana, for instance, before December 2020, then this caveat does not even corner me in any way. Is that correct?
What is traditional marriage?
Well, as people will say, I went to engage the person back in Ghana, I did the engagement, or I went to see their family. I wasn't there, but I had my representatives go in there, presented the diary, the drinks, and all the rest of it. Would that qualify me?
So mind you that at the moment, EU rules allow for EU SS family permits. So if you are abroad, your EU national spouse can still apply to let you join them, provided you married by the 31st of December 2020 or before that. What it means is that if you're able to prove that you married before 2020, 31st December, but you registered your marriage after that date, it's not the registration of the but the marriage itself.
Okay.
If I'm marrying in the UK, then there's no leeway because within the UK, there's nothing like traditional marriage home and later you go to register. The processes are different. So if somebody is in the UK and they have grant to marry or permission to marry in the UK from the Home Office or from the council, and they are not able to marry before the 31st of December 2020 for whatever reason, then they cannot claim to be family members of their EU national before the deadline. They became after the deadline.
Yeah, you were also talking about subsistent marriages where you may have lived with a person for 2 years and over. How do I prove that I was in that kind of relationship before the 31st of December 2020?
So the case law is quite clear, and it's peculiar to individuals whose marriage or durable relationship took place or takes place in the UK. That's the starting point. So if your you are in the UK with your EU national, and you were in a durable partnership before 31st of December 2020, you would have actually applied for a residence card, even if you were not married, and you could
Okay.
prove that you've been together in that durable relationship for 2 years. And we call it durable relationship because such relationship is similar to marriage, because you
Okay.
do everything as if you were a couple.
All
And
right.
how do you prove that? You prove that by all the joint arrangements you have to do with your finances, your life together, as a child involved, and all those things. You can have things to prove, living together, sharing things in common, and all those things. Now, if the person has not lived together for 2 years,
Yeah.
let's say by 31st of December 2020, if you count back, so we have 20, so we have 2020, the whole of 2020, then we have the whole of 2019. You can say that, well, you've been together for 2 years. But if you have only been together for 1 year, then you are not in a durable relationship because it has to be 2 years. If you are not in a durable relationship, then you have to marry the person. If you are married a person, then you have to do so before the 31st of December 2020. So the question is, one, were you in a durable partnership or relationship, so that based on that, you applied for your residence card based on the EU provisions? If so, if you marry after that deadline, 2021, then because you're already in durable partnership, because you already had your card, marrying later doesn't change anything. But what we are saying is that because of the fact that you did not have your marriage by the deadline, and you had it after the deadline, you cannot rely on EU provisions for that.
Okay. So what lawyer is telling us, ladies and gentlemen, is that there's a caveat with this, and you definitely have to admit that the very significant thing, and the date is 31st December 2020. So those who married EU nationals after December 2020 or December 31, 2020 cannot get pre-settled status under EU settlement scheme unless they previously had or applied for an EU resident card or family permit as their durable partner. Even those who were waiting for their marriage to be approved because of COVID-19 do not qualify. The best route for these spouses is to apply under the immigration rules, providing evidence of language, maintenance, and accommodation. That's a far cry from the pre-December 2020 EU requirements, and that's based on a case, Selig versus Secretary of State from the Home Department, the 2023 case, England and Wales Court of Appeal case, CIV 921. And with that, let me do some of the house cleaning items here. Rebecca Mwako, thank you very much. Good afternoon, dear brother and lawyer. That's what you say. Thank you very much for joining us. Give to a Chime team. Good afternoon to everyone. She says, Papa Kwame is asking all of you to share. We also live on PAM TV UK. Pastor, thank you very much for sharing our lesson and our knowledge, and of course promoting the confidence we have for the community by courtesy of BWF solicitors. Nanajima, good afternoon to you, Lawyer Ansa, Asma, and Brother Kweku. You say, Gina, do say you're on. Tilly Duma, we are calling you to come on. Dr. Sadum calling you to come on. Nanajiman is asking us to share, and do that. Anita Japoma Japan, good afternoon to you and as well. Nana Yao Apia Kubi, thank you very much for us. You're giving us the claps, applaudissements, as the French will say. Kwame Jima, you're watching us from Osprey live on YouTube as well. Then we have Lyrical Black also watching us, giving us the thumbs up. And I'll give you the thumbs up as well because we are all together on this very wonderful platform in the community, and in the community, and the law brought to you by BWF Solicitors, and we're live on BWTV, also live on the various social media platforms for BWF Solicitors, Facebook, YouTube. Now, let me tell you, invite people to come and join us. Let's look at the algorithm and make it right. So far, we have over 200 videos there that you can go back and use as a reference point. The material there is so good that you can look back, watch it again, and empower yourself. Sometimes you can sit back and even answer all the questions yourself, or worst case scenario, approach BWF solicitors and they will give you everything you need. Fit and Well Network, good afternoon to you. Thank you very much. You're watching us on YouTube as well. We have another one, Asante Bernard, another great submission by my mentor, my advisor, Lawyer Asma. We are proud of you. Kudos to BWF solicitors. Daniel Lobin says, I salute Barrister Child. Lawyer Charles, what's the difference? Sometimes people get to confuse that. What's the difference between a barrister and a lawyer?
Right. I mean, they are both lawyers, but
Okay.
a lawyer, you see, a lawyer is anything. A lawyer. So in the UK, we have two classes of lawyers. So we have solicitors and we have barristers. If you go to other jurisdictions like Ghana and other countries, it's combined. So you qualify as a barrister, but you also can go to court as a solicitor to do certain things. Now, what it means is that in the UK, you have to choose which option or which one you want to pursue. In the UK, solicitors deal with the public. Solicitors do all the paperwork. We do all the things. We can also go to court, and we can, if high rights, what we call rights of audience, we can even go as far as high court. The barristers are supposed to do the advocacy, so they will serve as intermediary between the solicitor and the public. Most barristers do not have access to the public. If you want access to the public, or you want the public to come to you, you have to have the permission to do so, or the license to do so, what we call the public right access permission. So that is really the difference. We, the solicitors, deal with the public, and we instruct barristers to help with the advocacy work if we need them. Barristers go to court and represent the client on behalf of the solicitor. So those are the differences.
Right.
And with solicitor, I think it's also good to know that in the UK, once you pass your exams, you are called to the bar. And after that, you train to become skillful and experienced. But if you are a solicitor, once you pass your exam, you haven't finished. You have to train what we call the training contract. You have to go through the training and credibility in terms of integrity and in terms of all the things you need, the competence. SRA will approve you. So SRA regulates law solicitors, and the Bar Council regulates barristers. So those are the differences.
Well, Daniel Lobin says, I mean solicitor, but lawyer has explained the difference. Let me pick another one. Bethel Metalworks Limited. Good evening, please. I'm a UK as a student. Okay, we'll be coming to that. Bethel Metalworks, we'll be coming to that. So just keep your fingers crossed. I'll be picking that for our discussion later on. Now, this afternoon, as I said, we're going to look at switching successfully to skilled worker route from a student dependent, even if your spouse did not complete their studies. How do you do that? We're going to go through the practical steps of doing that, looking at what is required and what needs to be done, and the rest of it. Lawyer Charles Asma from BWF Solicitors is going to help us do that. But before we go on, let me remind you, and I keep saying this and I'll repeat, that whatever it is, there are 6 steps to everybody's life, from the cradle to the grave. Whatever happens, we will go. But when we are gone, what happens behind us? We have our wishes. We have things that we want people to do for us when we are away. We have our estate to leave to people we love. We want to have to continue our legacy and the rest of it. But tell you what, sometimes we don't document these things. And it becomes a problem when somebody dies without making a will or putting together a will. We say technically that the person died interstate. If you die interstate, there are laws that govern the way your estate is distributed. It may not be according to your wishes. So why don't you put your wish down? I'm advising you and inviting you to join or visit BWF Solicitors so they put your will and your probate together for you. We're taking a message, and when we come back, we delve straight into the discussion as the community and the law.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome back, and we're moving and soldiering on for our own good and for the community. It's the community and the law, and the discussion, as I said, and how to successfully switch to skilled worker route from a student dependent, even if your spouse did not complete their studies. Okay, so now I am looking at the dependent, I'm looking at the student, I'm looking at switching as a dependent or a partner of the student and all that. Lawyer Chansasma is here. Lawyer, first of all, the categories of people we're talking about are student, student dependent, and then we move on to where we want to switch to a skilled worker route, even if I'm a dependent of a student whose visa covers my stay here in the UK. Now let's unpick them. Who would be a student in the first place?
Right. So there is somebody who has been admitted to study in the UK at any level at all of learning, be it certificate level or diploma level or degree level or post, that's master's level or even PhD. Now, once you're a student, the school will admit you, offer you the sponsorship, come and study with them. You are a student. You can come with your family members, of course, until next year, January. Things possibly change. You will continue to bring your family members. So that is a student.
Okay. Now, the student, as we have been told earlier on by yourselves, educated as I should say, is allowed during school term to work for 20 hours. The spouse works any number of hours that the person is able to. Now, question then is, why would a spouse of a student want to switch to a skilled worker route? What would necessitate that?
Right. Why people do things are different, and therefore it depends on that individual's preference. But ideally, the difference between a dependent of a student
Mhm.
and a skilled worker is that as a dependent of a student, you are limited to the time of leave that your spouse has. So if your spouse has 1 year, yours is 1 year. If you
Okay.
came after your spouse had already been had already arrived in the UK, then yours is likely to be even less than a
Less
year.
than the year.
So what it means is that if you migrate from that to something else, it might give you a better chance of staying in the UK for a longer period than if you were on the student route with your partner or spouse.
Right. So, as a partner of a student, are there routes for you to be able to switch to a skilled worker route? And having gone through that, I would want to ask a follow-up question that what happens to the student when the partner has switched to a skilled worker route?
So, as a dependent of a student, you are not restricted in terms of where you switch to. You can switch to the skilled worker route, or you can switch to Appendix FM route. You now become a parent of course, there are limitations depending on who you are. If you're a female and you have a child in the UK, that child and the child's the actual father is British. The legal father is the student that you are married to. So you wouldn't really gain anything out of that. And of course, if you want to remarry, you should have divorced before you can remarry. So there are certain changes that you can as a dependent of a student, but to an extent limited. But one of them is switching to skilled worker route.
Right. The I think I'll come back to my follow-up question and ask, what happens to the student then? Would the student be able to turn the tide now to become a dependent of the initial dependent who has switched to a care worker route? Or they can maintain their respective positions and statuses?
Yeah, they can maintain their respective positions, or they can also switch to become dependent of the, insofar as it's not going to affect the conditions or the arrangement they have with the university. Yeah, so it's possible. All you need visa to study in the UK. So if you have moved to another category of visa and it's not contravening your admission arrangement, then you can pursue your course
Let's look at the
as a
scenario
dependent of.
as a dependent. Okay, so I have switched to become a dependent of a skilled worker, even though I'm still enrolled at that university. What will change? Because I have a visa to study. Can't I study when I'm a dependent of a skilled worker?
Well, if you're a dependent of a skilled worker, the benefit is that you are not tied to any employer
Okay.
and you are not limited to number of hours you need to work. So you can choose or you can choose not to work at all because you don't need any you don't need to please anybody, so to speak, as be especially an employer to meet the condition for your leave. And therefore, you can continue to study insofar as you can keep to the conditions of studies, the attendance and your work and so on and so forth. But if you are, of course, if you're a student, you could switch after 17th of July 2023. But prior to 17th of July 2023, that's have switched. If that student, for example, switched, so we're talking about pre 17th July matter. Pre 17th July matter is that student could switch. So if the person switched and one still wanted to go to or pursue the studies, then there's going to be conflict because you need to be on the course full time. At the same time, you need to be meeting your skilled worker conditions full time. Then you can go to then relinquish one.
Well,
But that conversation is no longer valid. We are now in post 17th July era, and that's the conversation for students.
okay.
Independence.
Now let us look at how somebody can switch. We have made and covered all our presumptions and assumptions. How do we go about it?
So as we know, you cannot switch for a student to a skilled worker or work visa. But if you're a dependent, you see, there is something we call a lacuna. A lacuna is literally a gap within, and drafters or legislators would always, they are human beings, and therefore it's likely that they will miss something. You will call it loophole. So what is the loophole in the law? The law says that if you're a student, you cannot switch until you have completed your course or your CAS has expired. Two conditions. But the same law does not touch the dependent. It did not contemplate the status of the dependent of a student. And that's the lacuna. And therefore, the lacuna can be beneficial to anybody depending on how you explore it. It's a loophole.
Okay.
Because the drafters did not contemplate that possibility. That if you are touching the student, do we touch? At the moment, they haven't touched the spouses of students. And what it means is that if you're a spouse of a student, you can switch.
There's something that says that an applicant who is applying for permission to stay in the UK on the date of application must not have or have been granted permission as a visitor, that all those details. Do they really apply to the spouse of a student?
So, Rakoko, if you can really share that with us, because that's going to be our starting point,
Okay.
so that we have the context to the conversation.
Right.
And when you finish, yeah. So if you can assist us with that. So this is an extract from Appendix Skilled Worker Case Working Guidance that came in when the rules changed in July 2023. So if we look at no, not this one. Please, we'll come to this one, but I want you to the first. Yes. So if we look at yes, paragraph SW1.5A gives us the conditions. But even that, before this one, there's one that spells out who can and who cannot. Let's start that one, please. So after that, we'll come to this, and we'll go to somebody who has tried it and what they said, and I'll tell you something. So it says that you should have that one.
Well, I will. Let me see if I can.
Okay, so let me read it out.
Okay.
So we have appendix skilled worker, and we have the paragraph SW1. So with SW15, it says, and that's the one you were reading actually. So if you can read that, just that I wanted you to show it.
Okay.
An applicant who is applying for permission to stay must be in the UK on the date of application and must not have or have last been granted permission.
Yes, that was the SW15, and must have been granted permission as a visitor, or as a short-term student, or as a parent of a child student, or as a seasonal worker, or as a domestic worker in a private household, or the outside the immigration rules.
Yes, so but that's not what we are seeing on the screen.
Okay. We'll try
Yes,
again.
good.
Okay.
Yes, so if we can get that later, so that people know the categories of people. So what the rules say is that under 1.5, if you want to apply to switch, you should not be a visitor. You should not be a short-term student.
Mm-hmm.
You should not be a parent of student, a child student. A parent of a child student is a child who is studying in the UK and a parent being here with them as their dependent whatsoever for care purposes. So if you look at A to F, there's nowhere in guidance or guidelines that it talks about dependent of a student.
Okay.
You agree?
Yeah, it doesn't.
So this home office's own guidelines, and this is what we call case working document. This is their Bible, and they have told the members that SW15, so appendix skilled worker, chapter SW15, verse A to blah 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 blah. There's nowhere it talks about a partner of a student. What it means is that if I'm a partner of a student, I can switch. I can make an application of that nature.
Okay. So that's where
Then
you
go
said there's a
to
lacuna.
that's the lacuna.
Okay.
That's the loophole. Now, so there's no way if I'm a partner, I cannot because it doesn't touch me. We know that student cannot. We know that visitors can. Students' case is even so broad that if you're a student, if you haven't completed, you cannot, and if your CAS has not expired, you cannot. But what if I'm a partner or dependent of a student? Can I? The law doesn't say no to you, and therefore you can.
Okay.
Now let's go to the conditions. So SW15A, an applicant who is applying for permission to stay. Permission to stay is the switch, permission to stay,
Okay.
and has or last had permission as a student must fulfill the following conditions. So you see that SW15A talks about student who cannot do what others can do in terms of switching, because
Okay.
you should have completed the course or you should have your CAS expired. So
Right.
if you haven't completed the course, you can't. What about my dependent? Can my dependent go ahead and switch? The rules do not say your dependent cannot, and so your
Cannot.
dependent can.
Okay.
So that is why we are saying that if you're a dependent of a student
Right.
and your student spouse could not complete the course for whatever reason, the reasons are genuine, you have opportunity to migrate to other things so that you can then what it means is that those limitations that your student, the main student have or has, which are likely to affect you, once you move away from where you are or switch, then you are liberated in a way. Then we can talk about if you can, that freedom can cover the student who is your dependent or your spouse and could not complete the course.
Right.
Let's move on to somebody who applied.
Okay.
Who applied and what they told the person.
It says you have attempted to make an application for permission to stay in the UK. Your application has been rejected as invalid and will not be considered for the reasons set out below. You have applied as a skilled work visa. You have applied for a skilled worker visa. You must meet the validity requirements stated in immigration rules appendix skilled worker. We have noted that your current course expected end date is 20th of October 2023. Immigration rules.
So let's pause there. Let's pause there.
Okay.
Now, we have said that your current course ends on 20th October 2023. Who are we talking about here, generally?
The student.
What does the student? It is the student who has completion date. Does the spouse or dependent have a completion date for a course?
But is it not a situation where we say the dependent of the spouse's visa length depends on the validity of the student. So if this one says your current course expected end date is 20th of October 2023, it means that if I, the student or the main applicant, is going away, I'm going away with my spouse. So impliedly,
That
that's
is
what it is.
that's the word used. Implied, implication, or presumption. And such presumptions can be rebutted.
Okay.
And how do you rebut that presumption? The presumption is if A equal to B and B cannot become C, then A cannot become C. That's the presumption.
Yeah.
But that presumption is rebutted. And how do you rebut it? The student is the one studying and has a completion date for the course.
Yes.
So in our scenario, 20th of October, the person completes the course. Now, we are also saying that the dependent is not studying, and therefore you cannot say that they have a completion date. You agree?
Yeah, the dependent is not
Being,
studying, so I agree.
I'm a dependent, but I'm not a student.
Mm-hmm.
And therefore, you can't say that I have a completion date because I don't have a CAS or confirmation admission to study, which has a deadline. Or I don't have admission, which has a deadline. I'm not attending any classes to have attendance record and to do exams and to the course. So it doesn't apply to me. So this caseworker, you can see that is making reference to the student and goes on to quote paragraph SW15A, which talks about all the conditions that an applicant, the one we read before. So if you go to the next information to talk to let us know what is the caseworker talking about with the specific application.
Okay, so it says an applicant who is applying for permission to stay and has or last had permission as a student must fulfill one of the conditions A, B, or C below on the date of application. A says the condition A, the applicant must have completed the course of study for which the confirmation of acceptance for studies was assigned, or a course to which
Who are we referring to?
ST, the student.
Still, who are we? The student. Good. So
Okay.
A is about student. Go to B.
Condition B, the BI says the applicant must be studying a full-time course of study at degree level or above with a higher education provider which has a track record of compliance. And two, the certificate of sponsorship in SW 1-2. And D, must have a start date no earlier than the course completion date, or okay, that's condition B. Can I read the C?
Yes, read this.
Okay, condition C says, C1, the applicant must be studying a full-time course of study leading to the award of a PhD with a higher education provider, which has a track record of compliance. That's a C.
Phil, you are making noise. Phil, you are making noise.
Okay. Sorry about that. There was some interruption, family interruption, so we will get on to that. So, Lawyer, I've read C. The certificate of sponsorship in SW 1.2D must have a start date no earlier than the course completion date. Or condition C, the applicant must be studying a full-time course of study leading to the award of a PhD with a higher education provider, which has a track record of compliance.
Right. So you can see that all this we are referring to the same person, the student.
The student.
Yeah. So if we are talking about the student and you use the same measure on the dependent, then you are not being fair as a caseworker. So when you challenge them, they then go back to read their own policy. They then realize that they've made a mistake and they will come back to say sorry. And what would they say? Show us what they will say when they come back.
Your application and skilled worker route of the immigration rules has been successful. You have been granted permission to stay in the UK as a skilled worker until October 13, 2026.
So before they said it's been rejected because it wasn't valid, because you couldn't switch.
Mhm.
And now they said it's been granted. Between that is the work of the lawyer,
Okay.
who understands the rules and can challenge them to rebut the presumption that the rules talk about student. They don't talk about student partner or dependent. And therefore, you can't touch the dependent. You can touch the student, yes. Because A, B, C, D, all these conditions refer to the student. So if I'm not a student, then you cannot use the same measure to judge my application. Because if you're a student and you apply, your application will be rejected because it's not valid, because you cannot apply if the course has not completed or your CAS has not expired. If I'm a partner or dependent of the student, you can't tell me that I can apply because I am not a student. And the conditions under paragraph SW 1.5 capital A do not apply to me. So when you push them and you remind them, they go back to check and they come back to say, you have been granted because we didn't do our checks right initially.
Is it something deliberate, or is just a lacuna, as you have said? Because whoever would have drafted the guidelines would have thought of some of these things, wouldn't they?
Right. Remember, when there is a loophole, everybody takes advantage of the loophole.
Okay.
The caseworker also has a right to use the loophole to his or her advantage. So remember, it takes somebody who is daring to challenge them. So if, for example, we did not challenge them on this, they would then say that, yeah, your application is not valid. So we'll refund your money to you because you couldn't have made that application. But once you challenge them, they sit back and realize that, oh, the person also knows what they are talking about. So they are taking advantage of the loophole. You also have to take advantage of the loophole and make your case stronger. And you can see that between that, it takes more than just writing to them. You have to write to them with conviction.
Write to them with conviction. And of course, if you have the courage to do that, you're doing that on the wings of BWF Solicitors, our trusted partners when it comes to the law. We're having a discussion on your ability to switch to a skilled worker route when you are a dependent of a student who, whether it's completed his or her course or not, you'll be able to do that. And as lawyer said, there's a lacuna, and I've referred to a decision that was challenged, and the result was that the switch was granted and the stay of that person was extended for that reason. We're going to take a break, and when we come back, we'll continue with questions to Lawyer Charles Asma, who's a resource person coming from BWF Solicitors, and we shall also be picking up the questions you put on the platform and also on our text and WhatsApp messages. And the numbers to use are for our WhatsApp line is 07950 422 780, 07950 422 780, or you can text and call us on 07399268468, 20848, sorry, 07399208468. So get ready. When we come back from the break, Lawyer Charles Asma will still be here. We'll still be riding on the backs of BWF Solicitors. I've seen that you people are sharing. Keep it going, share, because this is a great opportunity to learn so many things. Now we've learned one thing, lacuna, and the advantage of that is what Lawyer Charles Asma is telling us. We'll be right back.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we'll get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community,
is a member of the Family Law Panel
and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA regulated professionals, transparent pricing.
BWF Solicitors.
Let us take care of probate.
Well, BWF Solicitors, let's deal with probate, and they will help you draw up your will. Lawyer Charles Asma is our guest and resource person from BWF Solicitors this afternoon on the community and the law. Remember, BWF Solicitors has various education programs for you that will help you, one, understand the law, get you a bit more confident in doing what you have to do, and also to invite you to use their services. Will, applications for your immigration statuses, property, and all the other bits of the law, family, and all the rest of it. So talk to BWF Solicitors. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. BWF Solicitors are trusted friends when it comes to the law, and the evidence is clear. The knowledge, the skill, and the patience of Lawyer Charles Asma and all the other resource persons we get from BWF Solicitors, Uncle Ben himself, Lawyer Eunice, and the support staff is so wonderfully good. So trust BWF Solicitors to give you what you want. Lawyer Charles Asma is helping us to unravel the scenario where we want to successfully switch to a skilled worker from a student dependent, even if our sponsor or the spouse did not complete their studies. And he's taking us through one particular case that the challenge was put in and the caseworker had to rescind the decision. We're looking at that. Lawyer Osasma, let me ask this question in addition that when the switch application is put in, wouldn't the dependent make a reference to the initial applicant, which is the student? And when that is done, the implications, what would they be?
Right. Now, only references. If you make a reference to something, you are just signposting it. It doesn't make it that thing. So the applicant is the dependent of a student. They will ask the applicant, do you have a current leave? The applicant will say yes, because they have a current leave. They will ask what sort of leave you have. The applicant will say student dependent leave to remain. And it is the case. Does that make the applicant a student? No. It only remains the fact that the applicant is a dependent of a student who could not complete the course. Do we visit the punishment of that student on the partner? The law says at this stage, no.
Okay. Right. Then the student that could not complete the course, when the partner is switched to a skilled worker route, which makes the other partner potentially a dependent of the skilled worker, can the student use that situation and the new condition to continue the course and complete?
So the student, for example, let's say our case. This is a live case. This is a live case. It's something the person was made application, was rejected us, and we assisted in the best way we can, and that's the result we see.
Right.
Now, I told the person that yes, you are a dependent of a student, but you are not a student, and therefore you have to challenge them. And with the support, this is. But the key thing is, let's say this person is now saying that, right, I want my dependent or my who couldn't complete the course to get onto my ladder.
Yeah.
Is it permissible in law? So we don't have to be preemptive and assumptive. It is what it is. Now, this is a skilled worker migrant. So the rules that will apply to the partner who couldn't complete the course, the skilled worker migrant partner provisions.
Yeah.
So we read if we're applying as a skilled worker, what are the rules? The only bit that in this case will be a challenge for the student is that technically, has the student got leave to remain in the UK? That would be the hurdle. And it's a matter of argument because the student did not complete the course.
Right.
Yes. And the question is the leave still valid? Because if your leave is not valid, you cannot switch as a dependent of a skilled worker. So if the leave is valid, then it's a matter of argument going forward. If the leave is not valid, then you cannot even contemplate switching because you have nothing to switch from. Now, if the leave is valid, is that leave there as a student or there as something else? That leave is there as a student, but this person has leave to remain. The person cannot switch to the skilled worker provisions, but what if the person is switching to the skilled worker as a dependent of a skilled worker partner? Again, a lacuna.
I love that word, lacuna. but the lawyers will use that to your advantage. So talk to BWF solicitors. You can come join us via text or voice. The studio number is active now 073-9920-8468. Or you can send a WhatsApp voice note or text to 07950 07950 or 073-9920-8468. That's our text number. Or you can even call on 0208 123 1016 0208 123 1018. We're live on BWTV and all the BWF solicitors social media platform, Instagram, Facebook, YouTube, and LinkedIn. Yes, that's the one I needed to do that. So keep sharing, keep liking the page, subscribe to the channel, and then you'll be notified anytime we put content on. Margaret Edumensa is asking everybody to share as many times as you can. It's free legal advice and it's coming from BWF solicitors. Emilio Joe, where you are, we're looking for you. Margaret Edumensa is asking people to share or calling on Nanaji Man and saying good evening to all the people that are around. Ship Ni Ashon Manche. Great work, lawyer. Thank you. Sandra Fraser's come up with all the details and the telephone numbers and the directions for BWF solicitors. Fourth floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, 0208-493-7340. Or you can send an email to admin at BWF solicitors and that will be picked up and addressed. We also have, Better Method Works. Yeah, earlier on I mentioned that I was going to keep your question and put it to lawyer when we come to that segment. Good evening, Better Metal Works Limited says, please, I am in the UK as a student, but I did not go to school. What should I do to change my document? Lawyer.
If you did not go to or did not complete your course, the rules say that you cannot switch to the skilled worker provisions. So skilled worker is out for you. It's not an option. What if whilst here illegally because your visa maybe is expired or is being cancelled, you have a child and the child pre-settled status because of their dad, or has settled status because of their dad, or has British citizenship because of their dad, then you being a mother or a parent of a qualifying child, you can request to be granted leave to remain in the best interest of your child under the relevant provisions of the law, especially Section 55. The question is, at the time you conceived child and the time you gave birth, not even conception, at the time you gave birth to the child, the time the child was born, who were you married to? If you were married, then the child belongs to the person that you are married to. So if you're a student here, you couldn't finish your course, you have a child, but you came with your partner from home or abroad, and because you didn't finish, they couldn't also finish, and therefore both of you have lost your leave or about to lose your leave. You have a child for another man. Who is the father of this child? The law says that the father of the child is the student that the dependent that you came on the student visa with. That's the father of the child, not the citizen or the EU citizen who actually had the baby with you. And we said that we have legal fathers and biological fathers. The law sees legal fathers as the fathers of the children if the children were born at the time the mother was already married to another man.
Yes, you can come up with your question and your concerns, and we'll do that. Asante Richard says, please, what if the student visa is curtailed? Can he or she be a dependent?
I think we have, so I answered this previously.
Yeah.
That if you are a student, can you switch to join as a dependent of a skilled worker who was before your dependent and has succeeded in switching. One, your visa is not expired, you can switch. Every switch, you should have a visa. If your visa is curtailed, then there's nothing to switch from. So that is no. So in this situation, we say no, because there's nothing to switch from. But if the visa is not curtailed, then it's a matter of exploring the legal gap or the lacuna in the law to say that can this student who did not complete switch to join or to go on the leave of the dependent who was previously his dependent. Our brother's case, visa is already cancelled, so there's nothing.
Nothing. Okay. We go on to the next one. It says, please, I have been granted 30 months, that's 2.5 years, leave to remain status on the 10-year partner route under paragraph DLTRP 1.2 of Appendix FM since 2020. This permit expires in December 2023 and is due for renewal. My partner and my twin kids recently attained indefinite to remain status. I would appreciate it if you could kindly advise on the following. Which route can I switch to based on the circumstances to shorten the 10-year route? What are the requirements? Which application form do I use?
So let's separate our brother from the family members.
Okay.
The family members have indefinite leave to remain, but it doesn't mean that covers him. He's still on his way to indefinite.
Okay.
I don't know how many 2.5s he's had so far. If he had only had 1 2.5, technically he could have switched to the 5-year route. But what the Home Office is saying is that if you are living with your partner and the child and as family unit, that falls under Gen 3.2. On that basis, even if you switch to the 5, you'll be put back on the 10. I don't know why they do that, but I suppose they don't want to create a floodgate for a lot of this to happen. So when you open it, they close it for you. And that's a challenge. But if our brother has already done 2.5s, which is already 5 years, then there's no point switching, because even if you switch, you are starting again. So starting again for 5 years with a lot of restrictions, then stay where you are for 5 years with no restriction and complete your journey.
Okay. We have one on the platform again. It says, lawyer, my mother is 20 years in the UK. I'm here to apply her 20-year long stay. She's over 75 years now. Please, the application is a straightforward thing that I could do by myself. Also, can I apply for a Home Office fee waiver for her since she has no money because she has no right to work here? Thanks. Also, will she be able to have some support to earn a living here after the application is successful?
Okay, so yes, our brother is saying the application is straightforward, and therefore, if you think that you can do it, of course, that's this free legal education. We empower you to do it. However, be mindful of the law. In the past, this was called long residence, 20-year long residence. The law has changed. It is no longer called 20 years long residence. It's now called private life, and it falls under appendix private life. There's also separate appendix for long residence, which is defined separately. Therefore, much as you know what to do, just be mindful that you don't get them mixed up and have your application declared invalid, having to start all over again. The next thing he asks is, can the mother apply for a fee waiver? The answer is yes, provided it is true that she doesn't have savings, she doesn't earn anything, and her bank account shows that she cannot afford the application fee. So she has to prove that. Can she get? Can she be granted the leave with recourse to public fund? Potentially, if you ask for it.
Okay. The next one I am picking from the platform. Keep them coming through either via text or WhatsApp, and we'll pick them up and lawyer will address for us. Good morning. It's afternoon. Okay. Do children making registration as British need to enroll for biometrics?
Yes.
Children. Okay. All right.
So the parent will go with the child.
Right. A straightforward answer there. You'd have to do that. Mary Chichokote, you're watching with us. Thank you very much. We also have Asante Bernard watching. Daniela Che Mensa, thank you very much. Mercy Smith, you are watching. Thank you. We have Margaret Mensa. Yes, I mentioned that already, and the host of others that are watching. Yes, we're getting so many likes, we're getting so many loves of the thing, and I'm asking you to share. Let's get to about between 300 and 400 shares for today's program. My wife and I. Okay, let's look at Luke Collinson's one. If I am an illegal immigrant and living with British child and a mum as a stepfather, how many months can I apply for a stay as a student who couldn't finish his course? Lawyer.
Is it the one on the? Okay, so the one on the screen.
Yes.
So illegal migrant living with a British child and the mother. So this person is a stepfather, I suppose, as a
Yes.
stepfather, yes. How many months can I apply for a stay as a student who could not finish? Okay, so it doesn't really matter whether you finished or not. That's why you are illegal. And because of that, you can explore your options. One of your options is that you apply as a stepfather of a qualifying child. So you are living with the child's mother and the child, and therefore you should prove that you are playing an active role in the life of that child. If that is the case, you'll be granted 2.5 years leave to remain, 30 months.
Okay. The next one, it says, hello, my wife and I came to the UK as students separately, but I didn't go to school, but my wife did and has completed. Can I switch as a dependent on her visa since we are married? Also, if she has a skilled worker visa, can I still switch onto it as a dependent?
The question of whether this person who came separately has valid leave at this point. If the leave is curtailed or expired, then you cannot switch because you have nothing to switch. So if that question is answered, then we can explore the subsequent questions that he's posed. Because if there's no leave, then anything about switch is out.
Okay. Right. So let's keep going. Grace Hammond says, can a student who exceeded the 20 hours a week but completed school switch to a skilled worker or PSW? What would that be?
So I suppose a skilled worker provision.
Okay.
Post-study worker. So the post-study program is different from skilled worker. So this person has two options. They have completed the course. Exceeding the hours, it's a breach of your condition if you are found. So if the university discloses that to the authorities or the Home Office, then it might be a breach of your condition. At this stage, should I say it's a minor point? The key point is I have completed my course. Can I switch to skilled worker? My leave is not expired. The answer is yes. Do I also have the option of applying for extension as a post-study for the post-study leave? Yes, you can apply for post-study leave. What is the difference? For skilled worker, it leads to settlement. But for post-study, once your 2 years post-study is expired, you cannot extend because you only have 2 years to gain experience and skill for your CV and go back. Unless the employer is happy to progress you and they give you sponsorship, then you can do something about it. So post-study does not lead to settlement. Skilled worker leads to settlement.
Right. Last month, you know, this skilled worker route, care worker route, and all the other bits, there are technicalities around it, and yourselves, BW solicitors, you have been letting people know what to do, how to do it, and the rest of it. Last week, for instance, I guess we remember there were people complaining about coming in and they don't have jobs, and the question is, how do you even find out that people have jobs? How do we, if I have vacancies, how do I go about it so I can continually have vacancies to be able to employ people this because this scheme is still on. Next week on the Community and the Law, watch out for very practical evidences as to how to do that. We shall be bringing resource persons, people who have businesses and they are doing the things right with the support of BWF solicitors, of course. We'll be bringing such on the program. So you don't have to miss that for all the good at Obuasi. Definitely we'll be having a good discussion and you know what to do. And probably we can signpost you to where to go when things are very tough for you. Call BWF solicitors on 0208-493-7340 or 077-127-61884. You can also call Charles Asma directly on 07947 636037 07947 636037. It will be put on the screen very shortly. So if you want to get in touch with lawyer Charles Asma, you can do that at your convenience. But on the program, we are live and we using 07950422780 as our WhatsApp or text message line, 07950422780. Or you can call the studio line 0208-123-1016. This afternoon, we're discussing how to switch to a skilled worker route as a dependent of a student, even though the student may not have completed his or her study. So, Lawyer Charles Asma, as I said, is taking us through the very interesting and technical word known as lacuna. And he's told us what to do, how to challenge that. But in between what you have done and what the caseworker has done is the lawyer. So consult BWF solicitors and let them help you as well. We're going to take another quick break. And when we come back, we definitely will be looking at some of the questions you brought in and other bits before we draw the curtains down. Have you thought of writing your will? Talk to BWF solicitors.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing.
BWF solicitors.
Let us take care of probate.
We're back. BWF solicitors, thank you very much. Remember, they are on the 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, North London. Thank you very much, Lawyer Asma, for free legal advice. We are most grateful, but the decision from HM, Bernard Asante, I don't know what you are referring to. The decision from the Home Office. Well, obviously, if if there's a lacuna, there's a strategy, and it would be addressed by BWF solicitors. And as I mentioned, you can contact BWF Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And weekends, you can book for appointments. So 0208 493 7340 or 077 61884. You can also contact Lawyer Charles Asma himself now on 07947 636 037 07947 636 037. He will have time and help you through that. Well, as Sandra Fraser, thank you very much. I think you took the wind out of my sail. If you have any further questions for Lawyer Charles after the show, please contact him on the number as I put on the screen 07947 636 037. I want to remind you again that next week on the program, we will be bringing external guests out of BWF solicitors. We will be looking at how you can sustain the vacancies you have in your firm when it comes to the skilled worker route, especially the care worker route that people are complaining now that they don't have vacancies. They come in, they don't have jobs to do. The jobs are there. Several vacancies are available, but you have to do it right. And definitely, I would direct you to go and speak to BWF solicitors. Lawyer Charles Asma, let me come back to you. Thank you for your patience. Let me come back to you and ask, what would be the longest period when somebody is switched under the circumstance that we have been discussing? Would it depend on the contract that the person will get with the person that's providing the certificate of sponsorship?
Yes. So the certificate of sponsorship will confirm how long the contract will last for. So if the contract is lasting for, say, 3 years, then you're going to, and it also depends on the license of the worker or the sponsor.
Yes.
You cannot grant what you have. So if your license is expiring in 3 years, you can only grant that limit. So how long you get depends on one, the contract period, or the license period of the licensor. That's the sponsor.
Okay. Now, when you have taught us that when you're on the skilled worker route, it leads to settlement. Then after 5 years, if the person is stayed on, can do. Now, I have switched from a student visa dependent, which had 2 years and probably had even run through the 2 years or even a year. Can I use that in addition to what I will have from my new contract to count towards indefinite?
This is called hybrid.
Right.
Hybrid rights. Now, if you have a hybrid right, it's a mix of things, just like a mixed grill. There is everything in it. What it means is that if you want to count your legal residence, you can count all legal residents, student, 2.5, skilled worker, and so on and so forth. Then you go on the long residence route, appendix long residence. Because that rule says that if you have been legally resident in the UK for that long, 10 years, then you can progress. So those are the conditions. But you cannot use mixed student dependent or student visa with skilled worker visa and say that the skilled worker visa says that after 5 years I can get indefinite. And so I've done 2 years student, I'm adding to my 3 and get indefinite. It says 5 years on the skilled worker, not 5 years of legal residence.
Okay. If you have any other further question, please let us have it by text 0739208468 or by WhatsApp. It could be a voice note, or you can call 07950422780 07950422780. And remember, the BWF solicitors number is 0208 493 We have as our guest and resource person lawyer Charles Asma from BWF Solicitors helping us answer our questions and waiting for that. But before we move on, very shortly I will be coming your way with my question of the day and question of the week. And that's dependent on the nuggets that was put out by BWF Solicitors earlier in the week. In fact, it came out on Monday. So let's look at that again so to get ourselves prepared and ready for my quiz and the question that will be coming. So you try your hands on it, get ready for that. It says those who married an EU national after December 31, 2020 cannot get pre-settled status under the EU settlement scheme unless they previously had applied for an EEA resident card or residence card or family permit as their durable partner. Even those who were waiting for their marriage to be approved because of COVID-19 do not qualify. The best route for these spouses is to apply under the immigration rules, providing evidence of language, maintenance, and accommodation. A far cry from the pre-December 2020 pre-December 2020 EU requirement that the Selic and Secretary of State for versus the Secretary of State for the Home Department 2023 case. Somebody is asking me this question. Let's pick that quickly and put it on the platform, and we see what lawyer can ask. It says, Kweku and lawyer Asma, please, what are the processes and requirements of inviting someone from Ghana and Germany? Two jurisdictions, but inviting both of them into the UK. What are the requirements, lawyer?
It doesn't really matter whether the person is in Ghana or it's in Germany. What it is that the person is applying to enter the UK as a visitor. So you are looking at appendix visitor or the V provisions. If you are coming in as a visitor, you have to show that you will return, what we call the returnability test. What shows that you will go back? What ties do you have? Familiar ties, work ties, social ties, and all other ties that will compel you to go back.
Exactly.
So if there's nothing to compel you to go back, then on a balance of probability, it is possible that the caseworker will conclude that you will not return and therefore will not grant the leave.
Okay, all right. Somebody is asking the new visa fee, the new home office fees, not visa fees, home office fees. When do they kick in and what are they? When do they kick in, lawyer?
4th of October, 2023. Today is 30th of October, end of September.
30th of September. Lawyer, running ahead of time.
Okay. What I'm saying is that today is 30th of September.
Okay.
That means we have 4 days. Tomorrow is the 1st of October. What it means is that if you have application to make, do so before the 3rd of October. If you submit by the 3rd, you are fine. If you submit on the 4th, and the 4th will start from midnight
of the
3rd. So it is not the morning of the 4th, the midnight of the 3rd. So if you submit your application by 11 p.m., I won't even say 11:59 because the transmission can delay if internet is failing you. So by 11 p.m. of the 3rd, then you are fine. If not, then you fall under the new visa regime.
So the 3rd, Monday, tomorrow, Sunday is the 1st, Monday is the 2nd, Tuesday is the 3rd. So if you have any application to put in, then you got to do that by 10 p.m. latest, as lawyer has indicated, 10 p.m. latest on Tuesday. But what are the fees? Leave to enter for persons in the UK who are liable to immigration detention, 1,048, and is moving to 1,258. Leave to remain, 1,048. 1,048. That day I said, well, they said leave to remain, so it remains the same. Certificate of sponsorship, skilled worker, tier 2, Minister of Religion is moving from £199 to £239. indefinite leave to remain. Main applicants and dependents moving from 2,404 to 2,885. Naturalization, British citizenship from 1,250 to 1,500. Nationality registration as a British citizen child is moving from 1,012 to 1,214. Visit visa for less than 6 months is rising by £15 to £115. Visit visa long stay up to 2 years, £376, and is moving up to £400. Student visa from outside the UK will rise by £127 to £490. And for settlement applications, it's rising from 1,538 to 1,846. Then indefinite leave to enter army, 2,404 to 2,885. Well, with that, I am going to ask you to look at this question, think about it, and I'll come back to ask you what the answers are or what the correct answer would be. Benghazi Afari married Aisha Mabel on 1st of January 2021. They had been waiting for the Home Office to approve the application to marry since June 2020. Benghazi made an application under the EU scheme, citing the Home Office delay as a reason for marrying after December 31, 2020, and change prevailed, arguing that he had legitimate expectation that because he applied to the Home Office before Brexit, he should be allowed under the law that was in effect on June 2020. I'm going over the scenario. Benghazi Afari married Aisha Mabel on the 1st of January 2021, which is a day after 31st December 2020. They had been waiting for the Home Office to approve the application to marry since June 2020. Benghazi made an application under the EU scheme, citing the Home Office delay as a reason for marrying after December 31, 2020, and change prevailed, arguing that he had legitimate expectation that because he applied to the Home Office before Brexit, he should be allowed under the law that was in effect on June 2020. Now, question is Benghazi likely to succeed? 1, yes, because his application to marry was made before Brexit. 2, no, because an application for permission to marry is not an application for leave to remain. And 3, no, because he was illegal in the UK. So I'll look at the answers again. Yes, because his application to marry was made before Brexit. No, because an application for permission to marry is not an application for leave to remain. And 3, no, because he was illegal in the UK. Think about it, get going, and get me your answers in the comment section below, or send me a text on 07950422-780. We'll be looking at this together when we come back after this.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community,
is a member of the Family Law Panel
and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, we are back, and we're looking at the situation of our brother Benghazi. Benghazi is in a dire situation. He says he had reasonable expectation to marry, but Home Office says you did it after 31st December 2020, so it's not recognized. One can't give you that for your immigration status. What should my brother do? Is he likely to succeed when he puts in an appeal or challenges the decision? Well, three options. Yes, because his application to marry was made before Brexit. No, because his application for permission to marry is not an application for leave to remain. But we're talking about marriage here, aren't we? No, because he was illegal in the UK. What do you think? What are the answers? Let me have them. 07. Okay. Lawyer, Lexis, the last answer we answered, he says the process of both, are they the same? Applying for a visa from UK, from Ghana or Germany? I guess they the same.
They are the same. I think what he's confused about is that. Can you hear me?
Yeah, we can hear you.
Yeah, I think what our brother is not sure about is this. If you are making an application to go to Germany, to visit Germany, you apply German immigration rules.
Mm-hmm.
If you are coming to the UK, you apply British immigration rules. And
Okay.
that applies to any other country. What our brother is saying is that he wants to apply to the UK for two family members. One is living in Ghana, the other is living in Germany. But it's not where they are living, but where they are going. They are both coming to the UK, and therefore UK rules apply.
Okay. Right. I think I've got a couple of answers for my quiz down there. Ademununku says number one. What does number one say? Let's go to the quiz again. Yes, number one says yes because his application to marry was before Brexit. Okay. Sarah Indede says it's number two. Number two says no because an application for permission to marry is not an application for leave to remain. What do you also think? Let's get cracking. Bring them in the comment section below, either on Facebook, YouTube. Is it yes because the application to marry was made before Brexit? No, because the application for permission to marry is not an application for leave to remain. No, because it was illegal in the UK. Well, Alex, thank you very much for that. What's your answer, Alex? What's your answer to the quiz? Let's see. What do you have? Well, you're still writing, so I'll pick it up from the text. What are the rules? I don't know what rules you're talking about, Alex. So if you could clarify, that would be very good. Okay. Now, lawyer, let me bring you in and let's look at the question. Benghazi married Aisha on the 1st of January 2021. They had been waiting for the Home Office to approve the application to marry since June 2020. So obviously the delay was from the Home Office. He made an application under the EU scheme, citing the Home Office delay as a reason for marrying after December 2020 or 31st December 2020, and change prevailed, arguing that he had legitimate expectation that because he applied to the Home Office before Brexit, he should be allowed under the law that was in effect on June 2020. Is Benghazi likely to succeed? Lawyer, you're mute. Lawyer, can you check your thing? I think it's muted.
I think if you check from your end,
we can
because
hear you
yes,
now.
so okay. Better now, I suppose.
Okay, you can hear you now.
Can you hear me?
Yes, very well. Lawyer, we can hear you very well.
Can you hear me?
Yes.
Can you hear? Good. So we are looking at somebody making an application under appendix UU.
Mhm.
And the person is saying that my sponsor is my family member. So we want to look at when the sponsor became a family member. A sponsor here being a family member, we are saying that the person is a spouse. Now, this spouse became a family member after the marriage. The marriage actually happened on 1st of January 2021. What is the deadline for EU? Deadline for EU is 31st of December 2020. Was he a family member 31st of December 2020? No. Why? Because 31st of December, he was not married to the spouse. They married after 31st December 2020. 1 point. The second point is, were they in a durable partnership so that they applied for residence card? We are told that this person doesn't even have residence card from previous, and therefore this is the first time. But they are saying that their marriage delayed because of somebody else's delay.
Mhm.
The person delaying you doesn't make your marriage date early. The fact remains that you married on January the 1st, 2021. If you have any claim, you can go civil claim that person for delaying you in any way. But under immigration rules, we see you as becoming a family member after December 2020, and therefore the permission to marry will be separated from application for leave to remain, and the application for leave to remain will be decided on the basis of Appendix EU rules. Otherwise, what our brother will do is to treat it under Appendix FM instead of Appendix EU. But for this purpose, it will be no, because the application to marry is not the same as application for leave to remain. Why do we not blame the Home Office? Because the blame will be a different claim, not under immigration rules. It will be a civil claim.
So the answer is no, because the application for permission to marry is not an application for leave to remain. The explanation as lawyers giving, I would want to just summarize. Apart from EU nationals, the withdrawal agreement gives rise to residents to two categories of people, one of which is those who were family members of EU nationals by the end of the transition period. The second is those who were durable partners. This includes spouses, but it didn't apply to Mr. Benghazi because he wasn't married on time. And that's based on the case that we use for our nugget, which if we can quickly go back to that to just reiterate, those who married an EU national after December 31, 2020 cannot get pre-settled status under the EU settlement scheme unless they previously had applied for an EU resident card or family permit as their durable partner. Our friend was applying for permission to marry, not EU residence card as a family or family permit. So even those who were waiting for their marriage to be approved because of COVID-19 do not qualify. The best route for these spouses, as lawyer has explained, is to apply under the immigration rules, providing evidence of language, maintenance, and accommodation, which is a far cry from the pre-December 2020 EU requirements. And with that, I'll go to lawyer now for him to do the traditional summary of what we discussed today. How to successfully switch to skilled worker from a student dependent, even when your partner did not, or when your spouse did not complete their education. Lawyer, the summary of that.
Thank you very much, viewers and listeners, for keeping faith with us throughout this engagement. We looked at a simple scenario where your student, you come into the UK with a student-dependent visa, but the main student did not complete the course, and so they cannot switch. Can you switch as a dependent? The answer is yes. Would the Home Office tell you that you don't qualify because your main student doesn't qualify? The answer is no, they can't say so, because the rules that came into force from the 17th of July 2023 did not cover or talk about student dependents like yourself. Therefore, if you want to switch and your visa is not expired, you can switch. Is it so easy to switch? It is not so easy, because it's a technical argument you have to put forward. You are fighting the Home Office for the same right. They have the right to say you don't qualify. You also have the right to say I qualify, and therefore it's a matter of argument. Can you argue based on fact? You have to argue based on the law. And therefore, we say that please seek the services of a lawyer if you want to switch as a dependent from whose main partner did not complete the course. Speak to a lawyer. We have done it, we have succeeded, and we can do it for you if you wish to contact us for any help at all. So that is what we have covered. The rules are clear, and the rules does not include somebody who is a student dependent, and so you can switch. Step by step, you have to follow the rules and get it right.
Well, and that was the summary of that. Get it right. And if you are in doubt, speak to the lawyer. And you can speak to BWF Solicitors by contacting them on 0208-493-7340. And if you would want to get in touch with Lawyer Charles Asma directly, call Lawyer Charles Asma on the number 07947 636037 07947 636037, and he will help you with any further discussion. How to set up a successful domiciliary and care staffing company for UKBA sponsorship license will be our focus next week, and we have two resource persons who will be with us to tell us how they set up and how they are sustaining their business with all the vacancies they have. You don't want to miss that for all the go, Dr. Boasi. But in the meantime, I would want to ask you to visit BWF again for your applications, for your wills and probate, for advice on all legal matters. They work between 9:30 in the morning and 6 p.m. in the evening, Monday to Friday. The telephone number is 0208-493-7340. Lawyer Charles Asma, thank you very much for your time. And I believe that when we call on you again, we will have the chance to have you in our studios again to help us discuss all matters legal, especially when it comes to immigration matters. And to you out there, I want to say congratulations for staying. It's not easy going away from all your pleasantries and all the big things. People are having barbecues here and there, hanging out with friends and the rest of it. But you've sat down with us for 2 hours. Congratulations and thank you so very much. I appreciate that. I don't take that for granted at all. So to my studio producer, Professor Day, and to Sheila Ankara and Padmo Dudu, who've been doing the aesthetics and the admin, thank you so very much for doing that. And to Lawyer Eunice, Lawyer Charles Asma, and Senior Partner Uncle Ben, thank you for your sponsorship and again also your direction and content research. To the staff of BWF Solicitors, I want to say I salute all of you. Keep doing what you're doing and helping us as well, especially Sandra. When we come on the program, you have so much with everything that we need to have. So on behalf of all these people and the wonderful family of BWF Solicitors, and on my own behalf, I want to say have a good rest of the weekend. Enjoy your new week and a new month, and we'll meet you again same time next week. My name is Owusu Frimpong. Have a good evening.